right, welcome. I'm going to get us started because we have so much to talk about today. It's really terrific to see all of you. Just start with thanks for joining the Miller Institute for Global Challenges and Law and the Edley Center on Law and Democracy for today's discussion of emergency powers in trade after the Supreme Court's Running Resources decision. I'm Catherine Lhamon. I'm Executive Director of the Edley Center, and we are so lucky to hear today from Professors Elena Chachko and Grewal here at Berkeley Law, as well as Andrew Tutt, who is here from the Washington, D.C. office of Arnold and Porter. Andrew Tutt, just to say it, successfully represented the petitioners in Learning Resources versus Trump.
No, I wish.
More fun that way, but you can say what you actually did.
Oh, yeah. Well, so we represented and advised other parties in relation to the case. Neil Katyal, which I will talk a little bit about, argued and represented, and then Michael McConnell. So Michael McConnell and Neil Katyal were the two Supreme Court specialists. And I can talk about both of them. I think they're both amazing lawyers.
In addition to you. All right.
Well, I have argued and won 5 cases at the U.S. Supreme Court in recent years, including one this term. So,
all right. Well, he's going to talk to us today about what the court's decision answers and where questions remain, and discuss the aftermath in litigation that includes seeking refunds following that decision. And just to say it, as you mentioned, it's argued a bunch of times in the Supreme Court, and Tutt's litigation practice focuses on the Supreme Court, as well as appellate and complex litigation. Professor Chachko will situate the Learning Resources decision in context of recent Supreme Court case law on emergency powers, drawing on her expertise in administrative law, executive power, national security, and economic statecraft. And Professor Grewal, as it happens, published during the first Trump administration about a need for a new research agenda for understanding trade law in that time. So he will share with us what the court decision means now for that understanding, focused particularly on international trade. So this is a terrific panel, and I am so grateful that we will benefit from their expertise for today's discussion. We're planning for each speaker to give about 10-ish minutes of remarks, and then we'll open for discussion at the end. So we'll start with Andrew Tutt to talk to us about the Learning Resources decision.
yeah, thank you. So like many Washington, D.C. Supreme Court lawyers, I followed the case extremely closely. Basically, every Washington, D.C. law firm had parties that they represented that were sort of interested in the outcome of the case, asking us questions about what was going on. And we were all thinking strategically from the beginning of these litigations about what the arguments would be, what the likelihood of success would be, how these cases would be shaped. So, what I can give is kind of an inside look at what maybe a Supreme Court lawyer sees in these cases that maybe you wouldn't see if you were not sort of steeped in what the court does on a day-to-day basis and the internal sort of machinations of that place as an institution. I actually think that the case, just to step back, so Learning Resources and VOS selections are cases about whether or not IEEPA permits the president to impose tariffs on basically every product that enters the United States for an unlimited duration in a potentially unlimited amount. And IEEPA is a 1970s emergencies statute that permits the president to essentially block, regulate. It gives the president a ton of powers. Justice Kagan, in her opinion, calculated 99 different things that IEEPA allows the president to do, although she then notably said imposing tariffs is not one of them. It is a super broad, it is traditionally thought of as the sanctions statute. It has been used since the 1970s to impose international sanctions on Iran, and has been used many times since for various reasons and in various ways. It stems from a long line of predecessor statutes that I'm not as much of an expert in, but I imagine Professor Chachko is. The bottom line holding of the case was that the IEEPA does not permit the imposition of tariffs. So the actual bottom line holding is no tariffs of any kind may be permitted under IEEPA. That was not the only option that the petitioners had for what to argue or for the court to adopt. The court could have instead adopted some kind of argument that it doesn't permit these tariffs or tariffs of this kind. Instead, they adopted a categorical rule. We can talk about why the court was inclined to go that direction. but the court split 3, 3, and 3. So first you have Justices Barrett, Gorsuch, and the Chief Justice. And they said that this statute doesn't permit tariffs because the major questions doctrine, which is a doctrine that says that when a statute answers a major question, the Congress must speak with particular clarity about the issue, that this statute failed that test. So they said, you know, it says, the statutory text is regulate importation. That is the statutory text. And the question is, do the words regulate importation, when given to the president, mean that the president can impose a tariff on importation? And they said no, not because the literal meaning of those words doesn't encompass taxation, but because if you were going to give the president unlimited duration, unlimited amount powers of this nature, you would expect them to say something more specific. So that's 3 members of the court. They impose a major questions overlay. They say this statute isn't clear enough. 3 members of the court, Justices Kagan, Sotomayor, and Jackson, say they don't need the major questions doctrine. This statute doesn't give the president this power straight up. That's Justice Kagan's opinion. She goes through and she reads the statute and she says, you know, they can't find a statute in American history, they being the administration, that has ever used the word regulate to mean this. So I just use ordinary context and common sense to figure out that just using the words themselves, the word regulate in this context, doesn't mean the power to impose tariffs. So that was 3 other justices. Then there's 3 justices in the dissent. I think of as led by Justice Kavanaugh, joined by Justices Alito and Thomas, who say, hold your roles. Like, how can this not give the president the power to impose tariffs? This is an emergency statute. This is an emergency statute that gives him the power to literally stop all importation of all goods into the United States for a potentially unlimited duration, period. So he clearly has these incredible, extraordinary powers. He has to find an extraordinary and unusual threat emanating from outside the United States in order to even activate the powers under this statute. It was enacted at a time when Congress had a legislative veto, so they were likely to delegate more power because they knew they could always veto it back. That was struck down. Congress doesn't have the power to do that, but the statute remained in place. So he says, just like, when I look at context, when I look at meaning, I say this either satisfies the major questions doctrine, or if it doesn't satisfy the major questions doctrine, then honestly the major questions doctrine shouldn't apply in this context because it makes no sense. This is foreign affairs. And as the majority said, you know, taxation is the central power of the Congress, Justice Kavanaugh said foreign affairs and protection of the country is the central power of the presidency. So those were the center fault lines of dispute. Justice Thomas also wrote separately, as did Justice Jackson, as did Justice Gorsuch. Justice Gorsuch to criticize all of his colleagues in their interpretive methodologies. Justice Jackson to say legislative history is very good and it just solves this whole case. So I don't know why we're writing super long opinions. Justice Thomas to say, like, you know, I think that Congress can basically delegate all of its powers in this area, so like I just don't see a problem with this at all. I think this isn't even a close case, like the president just super wins. So that's the lay of the land of this case. Things I find interesting about the case, and then I'll turn it over, are that this opinion is very much a sort of the Supreme Court sitting as the high court of the United States opinion. So the Supreme Court sits in kind of 2 postures. One is just to solve sort of nitty-gritty like conflicts, and then in a few high-profile cases, it recognizes that it's in the political mix. But something that was really extraordinary about this case was how it took on the mantle of being this symbolic, important case where they were going to brush back the president. For instance, just to give you one subtle example, the case is called Learning Resources versus Trump, but the actual case that was decided is a case called VOS Selections versus, I think, United States or something like that. So in other words, it's like they really wanted to make sure Trump's name was right.
Department of Commerce.
Department of Commerce. Yeah. Because, right, you can't sue the president. So like there was a certain flavor of literally the case that was dismissed for lack of jurisdiction is the case that has the case caption. And the case that was actually decided is the one that is sitting as like the one that nobody knows, the US selection. So that's kind of funny. But for instance, the court wrote an ultra minimalist opinion. I mean, you couldn't write a more minimalist opinion than this one. Every question they were permitted to leave unanswered, they did leave unanswered. And one of the things that was problematic about that, which was ventilated at length in the argument, was that the statute permits regulation of importation by means of licenses or otherwise. And multiple justices said, well, why doesn't he just force everyone to have a license to import in the United States and maybe have it correspond to, I don't know, a 10% surcharge on the underlying price of the product or something like that. There was a ton of argument about why that might or might not be an impermissible workaround or whether or not that would like defy the court. The court just doesn't say one word about the licensing idea, period. They leave that like a loaded weapon just sitting out there. Like if he wants to come at us and just say, you know what, we're going to do it by means of a nationwide licensing scheme, they basically invite him to do so, which I found very, very interesting. The other thing that was interesting was the timing of the release of the opinion, right before the State of the Union. You know, they have some choice in when opinions are released, and they intentionally chose to basically do it days before he could say that they suck to their face, which was a fascinating and intentional choice. So I found that to be interesting. Then the only other thing that I found really interesting that I just want to note, I mean I found tons of things interesting, but that I want to note to you all that you might not notice is the opinions, the separate opinions in the case by Justices Gorsuch and Barrett in particular, and Justice Jackson to a lesser extent, are extremely, and actually Justice Kagan, are extremely inward focused. So this is a case about the nation and about like, we all are suffering under a 10% nationwide tariff, basically, even right now, because he reimposed them under other trade authorities immediately. And so it's like everyone is feeling this, and yet all of the opinions are hyper specific about, like Justice Gorsuch literally writes an opinion where he just goes through and talks about interpretive methodologies and the history of England for like, I don't know, 30 pages. And like how English corporate law shows that the major questions doctrine is like the best thing, and it's been around since Lord Mansfield. Like there's just like, it's the most sort of navel-gazy kind of opinion, which is fascinating for an opinion that's supposed to be brushing back the president in this high court of the nation posture. And it shows, well, I don't know what it shows, but it's like, it's the opposite of Marbury versus Madison, I guess, in the sense of like, they really do not care that like, this is in that posture. They really want to convey that what they really care about is whether or not Justice Barrett is being honest about her view of the major questions doctrine. We're going to spend 5 pages talking about why she's not. Even though it's like extremely, so like this is an academic court, I guess. Like if you love doctrine and you love like law as like this weird debate you have in the office, like that is how they treated this case over like, you know, emergency economic powers was as a very academic exercise, so it's very interesting. Okay, so that's where I'll stop because I'm taking up a ton of the oxygen on this, but yeah, I mean I can want to say it. I'll give you guys a chance and I'll do questions.
Great. Thank you so much, Andrew. And it's hard to follow a Supreme Court litigator, but I'll try nonetheless. I want to start by thanking two really important people without whom we would not have this event. So Tony and Jenny Boyden, I don't see her. So just thank you so much for feeding us and for making sure everything runs on time. So what I want to do is to step away from the decision a little bit and to put it in the context of the Supreme Court's recent decisions, and not just the Supreme Court's recent decisions, the lower court's decisions, perhaps even more important than Supreme Court interventions, where it comes to presidential exercises of emergency statutes. And the argument is that under both Presidents Biden and Trump, the Supreme Court has pushed back pretty substantially against broad invocations by both of these presidents of various emergency statutes that give them a lot of power to regulate across different areas of the economy. And I'll just say a few words about our emergency regime. Andrew mentioned previous statutes and previous eras of emergency regulations in the United States. There was an understanding in Congress during that time, this was after World War II and during the Cold War, that those emergency authorities ended up giving the president way more power to regulate economic transactions during peacetime and not just during war. And so what came about is a major reform in the US emergency regime in the 70s through the introduction of the National Emergencies Act, which governs how the president is allowed to declare a national emergency that then triggers a bunch of other authorities, and the legislation of IEPA, which is the most significant, most frequently used emergency statute in the law books. What's interesting is, as Andrew said, in the beginning, throughout IEPA's lifespan, it was mostly used to address standard traditional national security and foreign policy threats. So think about proliferators, think about terrorism suspects, think about rogue states that the executive perceived over time pose a threat to US interests, from Iran through Cuba to more recently Venezuela, Syria, Russia, China. That was the traditional way in which IEPA was used. And other statutory provisions that are scattered across the US Code, I've counted 150 of those provisions that somehow delegate to the executive emergency powers, were also largely emergency authorities. They were used to address actual emergencies like public health risks, like natural disasters. But in the last 15 years, especially since 2010, we started to see those emergency statutes increasingly being used not for foreign policy and national security in the traditional sense, but for regulatory purposes that one would reasonably define as domestic. So you started to see emergency declarations related to protection of domestic industries, climate, energy, supply chains, technology, and more recently with the COVID-19 pandemic, there was this underlying emergency that nobody disputed was an actual emergency, but President Biden and President Trump invoked various emergency powers to do things with respect to that emergency that are arguably domestic, from trying to impose a large-scale eviction moratorium through, and that was sort of the major headline during the Biden administration, trying to forgive billions in student debt, an action that the Supreme Court eventually invalidated in a case called Biden versus Nebraska. So I call this trend and what we've been seeing in the practice of emergency powers by the executive in the last 15 or so years, emergency powers creep and domestication. And once you see that, you understand that while in the past, courts would defer to presidential emergency action because it largely implicated foreign affairs, considered traditionally as political questions, issues that invited a lot of deference from the courts. Now you're dealing with issues that increasingly implicate domestic administrative law and domestic constitutional law. And that means two things. One, litigants have more claims available to them to challenge those policies. And there are also more savvy, more sophisticated, and more powerful litigants that are able to bring claims against those actions. One example I'll give you, during the first Trump administration, this seems like ancient history, right? Ancient history. But the Trump administration issued an executive order trying to effectively ban TikTok and WeChat in the United States under IEPA. Now, this was something unprecedented in IEPA practice, historically. And the administration flew too close to the sun. It invited substantial litigation by TikTok, by WeChat, by other actors that tried to challenge the policies, and lower courts eventually enjoined those actions until President Biden came into power, revoked those executive orders, and chose a different pathway to pursue concerns related to TikTok and other Chinese-owned applications in the United States. So what I argue, among other places in the recent paper, if you have the energy to read 66 pages of a law review article, this is expensively described there. I argue that this shift in the way emergency powers are being used also invited more robust judicial review, greater willingness to deploy standard tools of statutory construction and standard doctrines of administrative law and constitutional law, and bringing those to bear on matters that traditionally were perceived to be outside the purview of the courts, things that courts should have deferred, issues where courts should have deferred to presidential action, and places where the courts were largely absent. So think about, I mentioned the WeChat TikTok litigation, the border wall that Trump tried to fund during his first administration, and was blocked by some appellate courts, not all appellate courts, but some appellate courts until, again, Biden came into power and shifted course on that policy. Then we had a strand of COVID-related cases where the Supreme Court, time and again, largely through its shadow docket or emergency docket, intervened to block various policies, including the student debt decision that I already mentioned. And then moving on to the current administration. And we continue to see that unfold, especially in the lower courts, because some of these cases have not yet ripened and reached the Supreme Court, or at least the Supreme Court was not willing to resolve them on the merits when it had the chance to. One example is the Alien Enemies Act, an emergency statute that the administration used as a tool for mass removal of individuals present in this country who the administration said were affiliated with the Tran-Darago cartel of Venezuela. The Supreme Court had several occasions in which it intervened, provided more due process protections to individuals that were subject to this statute, but ended up not resolving the merits of the case. This is now being litigated in the lower courts, and the lower courts have been very skeptical of how the administration has used this emergency authority. And, of course, the most substantial example of this dynamic and the shift in judicial review that it precipitated is learning resources. You cannot think, and Andrew alluded to that, of a more major case for the Supreme Court to step in and to invalidate a key presidential action, ostensibly for national security reasons, although we all have eyes and we can all see that the motivations for the tariffs were probably not quite traditional national security concerns, right? And so that is, in my view, in my opinion, sort of the culmination of these processes where we have seen this deep shift in the practice of emergency powers, a response from the courts, and the Supreme Court being willing to rebuke the president on a matter that's central to his agenda and has been in the news since President Trump came into office for the second time, like tariffs. And I'll stop here and I'll...
Great, thank you. Thanks, Elena, Andrew, for coming all this way. Catherine and all the Edley staff, I appreciate it. So I'm going to sort of continue the backing out to the bigger picture from the details of the case. I think that's my task. I teach international trade law here. I see some faces from the class. As I wanted to say, actually, Catherine was kind to mention that I published a piece during the first Trump term, early around like 2016, saying that three things we needed to keep a focus on in terms of thinking about trade law and policy. The first was the link between trade and inequality, which I argued would have domestic repercussions. This now seems almost too obvious to state, but it's really striking if you go back before about 2016, the tenor of trade law scholarship, which I was involved in then, it was very doctrinal. It acted as if this was, especially at the international level, this was a regime that had been well worked out by technocrats. It would ostensibly last forever, and the U.S. would be its anchor forever. That was just 10 years ago. And so what I thought that it looked to me like a pressure chamber about to explode, but that was not the consensus view among elite law school people who taught international trade law. So I said, we need to focus on trade and inequality, including the domestic political repercussions of a highly unequal world that trade acts as an accelerant on. Second, we should expect the return of geopolitics to intersect with the trade regime, and I pointed out the national security exceptions would be the the hole that that truck would be driven through, or whatever the metaphor is. And the third thing I said is we need to think about finance and the role of the US dollar, because that's deeply tied, is deeply tied to the, the trade is not barter, international trade is not barter, there's always a financial counterflow, and that's actually often doing the work. What we see in the trade world is often the ricochet from something happening in finance. So I think that, I wanted other people to join me thinking about these things. To some extent, folks in Biden land did, which was nice for a brief while. I think people in the Biden administration took seriously the problems in the international trade system. Like many things that Biden land tried to do, it wasn't able to get as much done practically as it saw needed to get done. And so now we're back with Trump 2, with I think all of the things I'd mentioned being still on the agenda, but on steroids now. Let me just focus on IEPA and the culmination of just of three broader trends to put this in yet more context. The first is just to completely echo what Elena said about the increasing use of executive emergency powers. And then I guess we could back out and say, well, what causes that? And it seems obvious, and this is, I think, the Chief Justice wrote about this at the end of the opinion. It's basically gridlock in DC, by which we mean really hyper-partisanship and the breakdown of Congress. To the extent that this is an Article 1.8 power, it's Congress's problem that this is, I mean, in some ways, all of this question of major questions, it's all downstream of the fact that Congress isn't acting. It's not able either to tell Trump what it wants to do or to withdraw its consent. And so what we have in the system now, tied to hyperpolarization, breakdown of Congress, IEPA being just one example, is something like a showdown between the presidency and the court for who really runs America. And it's interesting that it's very, very complex politics in that, but it's a moment where it's like, are we basically a jurisdicratic review system, or are we an unbridled presidential administration system? And you get people actually claiming, both parts of it, depending on which day it is. This is, more broadly, I think, let me just focus on two other trends besides the increasing use of emergency executive powers. The first is what's been called the imperial presidency, sometimes in discussions of foreign affairs power and war making. And so there's a way in which this trade and war, though, have always gone together in the rise of the imperial presidency. And what does imperial presidency mean? It means that powers that Congress has always been understood as Congress, like war making, declaring war, which I say today, of all days, for God's sake. And trade were seen as congressional powers, and the increasing delegation of them to the presidency is not just a post-World War II story. It goes back to the Depression. 1934 Trade Act under Roosevelt was one of the first big moments where Roosevelt basically says, listen, Congress, you're too slow. You can't work efficiently with foreign counterparties. Therefore, this is, properly speaking, something you ought to delegate to me. There were earlier, in 1898, there was a statute, McKinley had some of these powers and so on, but basically it was New Deal, presidency going to remake the country through executive power, and then after World War II, when the United States has to step into this global leadership role with the vacuum in Europe and Asia, that becomes the model. Delegate to the imperial president, I say he advisedly, he'll manage things on the global stage, and then, then in Vietnam, and all the fights over war-making powers in Vietnam, in some sense, this is the trade counterpart, but it's baked into the imperial presidency in its rise. The second point, then I'll stop talking in terms of the big story, is none of this would have been on the agenda without the breakdown of the WTO. Now, in other work, I've said that the WTO was unsustainable. I'm happy to talk about what I mean by that. But just to focus on it for the moment, all these IEPA actions are blatantly inconsistent with the covered agreements that the United States signed up to. So without the fact that under Trump 1, the appellate body had ceased to function, there would have been an international check on this use of domestic power. But at the moment, although they're all, again, they call it inconsistent, we could just say more illegal under WTO law, they'll be appealed into the void, which is to say there could be a case against it, as with the national security cases, but there will be no WTO check on it. So the imperial presidency is basically trying to unilaterally remake world economic relations through the deal making with allies and so on after the April 2nd so-called Liberation Day tariffs. But that's only taking place in the shadow of the fact that the WTO has ceased to function. So no one really understands, I think, at this moment at the international level, how world trade and world finance are supposed to be structured. There's a residue of kind of half-functioning institutions left over from the mid-90s, intersecting with all kinds of domestic competencies and debates over domestic competency. This is, you know, emphatically a United States story, but it's not only a United States story. Given the breakdown of the kind of ordering dimension at the global level, every country faces its own version of this problem, and then all of that then intersects with what the U.S. is doing as a model or caution. So I think, and I said the WTO was unsustainable. All I mean by that was to go back to what I said should be on the agenda for the first Trump presidency. I think the WTO wasn't fit for purpose in a world in which we see the return of geopolitical conflict, especially among trading parties. It just wasn't designed for that sort of a world. And second, it presupposed a particular configuration of market versus state at the domestic level. And emergency powers are one of those places when the line gets redrawn radically and quickly between market and state. And so it's not a surprise in some ways that emergency powers, especially of the executive powers, are being invoked at a moment when the market-state relation that the WTO and the 1990s presuppose has been radically upended. So those are sort of big conceptual things. Happy to talk about any more of that in relation to whatever you like. Thank you.
Great, thanks to all of you. And I have a series of questions, but I'll just pause and see if people have burning questions they want to start with now. Otherwise, jump into mine.
Hi, thank you guys for speaking. I guess high level.
Introduce ourselves. Would you introduce yourself when you? Yeah. When you
And your affiliation.
And your affiliation. That'd be great. We have a visitor, so that would be, I think.
My name's Dawson. I'm a 2L. I work on a slip that works with the Edley Center. So happy to be here. Thank you guys for speaking again. I guess high level, you guys kind of touched on this, but to what degree did the decision actually limit the president's power to impose tariffs? And if the answer is like not that much, how fair is the framing that it is actually a showdown between the courts and the presidency, and more so just a show of a showdown?
Well, so, I mean, I'll start and I'll just give my opinion, which is that it did almost nothing to constrain the president's actual power to do this. But that's not how it's interpreted. And, I mean, we just saw this in the Wong Kim Ark arguments in the birthright citizenship case. There are what the opinion does in its doctrinal and judicial world, and then what it does in the real world. So, you know, in that case, the Wong Kim Ark case says all over it that there's a specific fact in that case that's very important. And the argument in the new case is whether that fact actually mattered at all to the holding. In the actual legal holding, it didn't matter at all. But to the public perception of that case, it mattered a great deal. And so, in the same way, this case was all about optics. And there's a ton of things that it does do. I mean, the hundreds of billions of dollars in refunds are a huge embarrassment to the administration and massively inconvenient. I mean, this is an administration that has personnel and workflow and administration problems, and they are being ordered by courts to get refunds out yesterday. And they're like, I can't even get this out in like a month. And they're like, well, you got 7 days, and then I want a status report. So like people are just feeling like incredible pressure. Real things are happening just because this is something where he can flow around it. You know, there's always what he can do, and then how implementation will actually be carried out on the ground. You know, he does have to do all of the prerequisites, the procedural prerequisites. There are some limitations. He has to be more creative. I mean, the super convenient thing about IEPA is, read literally, it's like, do whatever you want. All you have to do is declare the emergency. I was in the Office of Legal Counsel, and this is recorded, right? Yeah. So I advised President Obama for 1 year, and I advised President Trump for about 1.5 years after he took office, and helped him with his transition when he first became president. This was in 2016. And an executive order came into the office about barring all entry of certain individuals from certain countries. And the original premise of the executive order was that I'm just going to do this under Article 2. I'm the president. And we said, he was informed that you can't do that, but there is a statute that says if it's a national emergency, you can restrict entry. And he's like, okay, it's a national emergency. So, you know, I mean, President Trump has never really, his view has always been, if I have to make a finding that it's a whatever, it's done, check it. Like, it's a whatever. Like, and so his view of national emergencies is, if it's something where I get to declare what it is, I mean, and we see this, for instance, in the Iran combat operations, because, you know, the president does have the opinion that Iran posed an imminent threat within roughly the exact amount of time required for it to not be considered an aggressive foreign war. So like lawyers in the Justice Department and the State Department over many years had formulated sort of crafted legal tests for when something constitutes self-defense of the United States. And lo and behold, the president is of the exact opinion that that is exactly the threat that Iran posed to the United States. So IEPA made that very easy. Other statutes do not, because other people are involved. And whenever somebody else is involved, it gets a little bit more complicated.
Maybe, can I just follow up one thing, which is to say, the recourse that he has to reimpose these tariffs under other statutory books is not restricted, but whether those are going to be fit for his purposes, to Andrew's point, is really unclear. So there's traditional remedies, anti-dumping, countervailing duties, safeguards. Those have a lot of procedure behind them, and even the more the more executive-friendly ones he could have, like Section 301 of the 1974 Act, which goes against unfair trade practices, which you could mention, you know, he feels a lot's unfair, says it regularly. Or Section 232 of the National Security Tariffs under the 62, I think, Trade Act. Even those have other people involved. He can't just kind of do an executive order. There needs to, commerce is often involved in things. There's also timelines, periods, I mean, it's just more procedural stuff. And so why does that matter? If the April 2nd Liberation Day tariffs were imposed partly in order to give leverage for deal making, then he could continue to impose tariffs possibly on some states under other statutory authorities, but they're not going to be the kind of thing where he can say, take a call from a foreign prime minister and say, okay, I'll get you down from 30 to 15 if you do X, Y, Z. It's not, so if what he wanted was a kind of deal-making authority, I don't see any other statute that gives him that, which is, I think, why his advisors found IEPA for this purpose. You want to, yeah.
Well, although there is, the president's taste for what we sometimes call jawboning, which is like a reference to a biblical passage. But what it is when you have some authority that you can threaten someone with if they don't give you what you want.
Yeah.
And he has been a huge fan of using jawboning as a way to get around these sorts of things. So, you know, it's true that it has to be done in a more
proceduralized.
Yeah, elaborate way, but it's like, if you don't give me what I want, I'm going to initiate an investigation, and in 2 months you're going to have 100% tariffs. So it's like a delayed punch in the face, but it does eventually get there, and so that would be that's kind of
how he's going to have to
he operates.
Yeah.
Yep.
I'm Bob Blushko. I'm not a lawyer, but I'm married to Pam Samuelson, so I'm often wandering around the building. I'm struck by the fact that I mean, surely these acts define emergency somehow. But if I ask anybody who's over 6 years old, they would say that emergency is something that happens suddenly and unpredictably, and none of that is true here. Why are we just debating the meaning of the word emergency?
So can I take this? The problem is that the US Constitution does not delegate emergency authority except in the authority to suspend habeas, right? So the statutory regime that we have essentially delegates the decision of what an emergency is to the president, without any standards, without any guidance.
There's no definition of it? We delegate it, but we don't tell you what it is?
No definition. The president is the sole figure that has the power to determine what a national emergency is for purposes of triggering many of those statutes. courts have never agreed to review presidential determinations of emergency. To the extent they've limited presidential emergency action, it was based on the interpretation of the scope of authority that the president invoked based on the emergency declaration and not the emergency declaration itself. That
But
is
my
why.
6-year-old kid test has got to be dispositive, Judge, isn't it?
Yeah. It's gotta be, but it is not, as a matter of practice.
Okay.
So if
I'm
you
not a
look
lawyer.
at international
You
definitions,
live with Pam long enough to know how this works.
Yeah, I know, but it's still staggeringly stupid.
staggering, but still. So Katerina Linos over there and I have done some work that looks outside the United States, that looks at other jurisdictions and the way they treat emergencies and the way they define emergencies. The European Union likewise does not have a definition of an emergency. International treaties do refer to emergencies as a threat to the life of a nation, something that jeopardizes the very existence of a polity, which I think relates to what you define as the 6-year-old test, right? This is a true emergency, this is what emergency authority is for. But the reality is, US law has not adopted that definition, and the president, the executive, is the actor that determines what an emergency is.
Do any state laws or anything define emergency, or is it just Constitution, which is that stupid?
I'm talking at the federal level. The state level,
Don't
just,
apply.
yeah.
And it's not, you know, so I argued a case that was actually referenced in this case at oral argument by Justice Kagan about national emergencies, where it was about soldier pay. Guard and reservists are entitled to additional pay if they are called up during a national emergency. The entire case was about what the word during means. The government took the position that during means you have to be called into that specific national emergency. There has to be a substantive connection. And I took the temporal position that during means in the same time as. So in other words, and all the hypotheticals, I think, in that case help to get what's really difficult about what a national emergency is. So Justice Kagan, who did not vote for me, was like, so what, we're just, let's say that there's like an emergency down in Florida, and then a guy is called up to go fight in Afghanistan or something, or to go do something else, like, and she just took as a premise that a Florida hurricane could be a national emergency. I mean, just like casually. Is it a national emergency? I mean, you know, it's not national, but maybe it is. It's not an emergency, but maybe it is. And so it's like, it's actually such a contestable concept when you actually start to really drill down into what count as emergencies. You know, during the argument, I did not get any traction on this. I'm like, you know, under the National Emergencies Act, Justice Kavanaugh, they have to redeclare the emergency every year. And he's like, why does that help you? I'm like, because it shows that the president's reanalyzing that it's an emergency and re-upping it, because there's been like a national emergency with respect to Iran since like
79.
yeah, and so, you know, the idea that the president is actually like carefully poring over the documents, oh my gosh, we gotta keep this one. So it's still a national emergency, is like not happening. But,
Just conceptually though, I mean, before we go full into the idea that an emergency is because it punctuated short term and a sharp change, I would just say, is climate an emergency? Are refugee crisis emergencies? Are long-term military standoffs of wars emergencies?
No.
Okay, so there may be things that you'd want to do about those things that would benefit from climate emergencies. And so I just wanted to note that. I mean, I would say I think climate is an emergency. Just because it's something that develops on a 40 or 50-year timescale doesn't mean we shouldn't treat it exceptionally now. So the question is, what work is emergency doing? Is, you know, now all the legal stuff applies, but I mean, imaginatively, I think we're in a number of long-term emergencies. Now, whether we can deal with those using existing statutory tools or whether we need a break would be then the further debate.
And maybe we should talk about also the things that you both, Andrew and Elena, you both mentioned about the major questions doctrine, speaking of things that are not well defined, right? And so, what brings us from this decision to better or more clear definition of what a major question is or isn't, and how do we operate now? So can you talk to us about that?
I think, sure, I think this case
You
muddy.
must love the major questions doctrine,
Oh,
though.
absolutely. It makes every private practice lawyer who challenges government action a genius. Like, I've discovered that this is a major question, client. But
And an emergency.
It took me a long time.
yeah, exactly. It's like I mean, seriously, when we were first starting to like tell clients like, we're going to call this one a major question, they were like, oh, that's never gonna work. And then it turned out it worked every time. It was amazing. But
Less fun in the binding decision, but okay.
right, so like, here you have a debate about where does it come from that's like extremely difficult, and then what work does it do and when should it do that work? All of those things are on display in this opinion. If you really want to see all the different tensions in that doctrine hitting at the same time, especially because you have the first time, I think, the major questions justices going at each other. You know, back when I once wanted to be a law professor as well, and I wrote a law review article about what happens when textualists disagree. Like, what do those cases look like?
That's interesting.
And this is a case about what happens when major questions aficionados disagree. We had Justice Barrett, Justice Gorsuch, and Justice Kavanaugh all giving us three views of, and Justice Thomas, of both what its roots are, like where it comes from, and what work it's supposed to be doing. I mean, Justice Kavanaugh's view in his dissent is like, okay, now it's gone off the rails. I don't even know what we're talking about anymore. Like, if the president can't be delegated emergency authorities to deal with international foreign affairs emergencies because Congress needs to be more specific, we were not on the same page about what this was supposed to be doing. You know, and then you've got Justice Gorsuch and Justice Barrett both debating, like, Justice Gorsuch is of the belief that it comes from the Constitution, that in order to protect Congress from the encroachments of the executive, which I know the founders would find like crazy because it's supposed to be the other way around, but we have to have this doctrine because it's the thing that sort of stops the president from just doing whatever the president wants in the face of Congress's inaction. And you know, Justice Barrett is like, no, that can't be right at all, and in fact, it would be a usurpation for us to say that's what it is. It's just a rule of language. If Congress really wanted the president to have this power, our duty is to give the president that power. My view is that they didn't want him to have it, and I just get there from common sense about my ability to sort of tell what the average Congress wants, which is a very like legal, there was a Harvard legal process school of statutory interpretation. It's back and it's better than ever. You know? So again, like we don't know, like Justice Gorsuch writes a dozens and dozens of pages trying to say that it comes out of the common law and from English history, going all the way back to Mansfield, and he cites cases from England and tracing all the way through the corporate charters of the colonies, all the way talking about how it's just a principle embedded in American law.
So can I just add a few things about the major questions doctrine? First of all, in the emergency context, I think the major questions doctrine is a contradiction in terms. Because every single emergency issue is major by definition, otherwise it would not be a major. And you would scarcely find a clear statement in an emergency statute that clearly authorizes emergency action because the very principle, the very drafting principle of emergency statutes is that they're broad and they're supposed to encompass a broad set of circumstances and eventualities. And that's why in that paper I mentioned, if you are so inclined to read, I proposed an entirely different canon that I think better aligns with just basic ideas of textualism and structure that have been around for 60 years. I call it the authority matching canon, and basically the principle is if there's a regular statute that applies to the circumstances like there was in learning resources, there's a presumption against interpreting the emergency statute as authorizing the action in question. And I think that's a lot simpler, a lot more anchored in long-standing practice and takes you away from this highly subjective inquiry of is something major, is something economically significant. And also as an administrative law professor, I think it avoids a lot of the collateral damage to the ability of agencies to regulate outside the emergency context.
Provocative food for thought, one sentence. As someone who's a fan of parliamentary government, this problem of delegation doesn't occur in parliamentary governments where it's about Parliament's ability to delegate to subordinate bodies that they've created, port authorities and so on. This is just a divided branches problem because you have coordinate and supposedly equal branches with foreign powers divided among both, so you're going to always have trouble. Welcome to the courts.
I'm kind of interested when you're talking about the major questions doctrine, that the rise of that is kind of at the same time as that, like, Congress has never felt so vestigial as like during this like presidential term, and so I'm wondering, do you think that like the growth and like the popularity of these these recourses to emergency powers comes from sort of the complete incompetence of Congress, or do you think that it creates that, or do you think it's both?
And also, what's your solution? That's why we're at it.
Vote is my solution.
Congress needs to perk up. The Chief Justice said that.
Yeah,
So
right.
I found myself in agreement about that.
Well, thank you guys so much for speaking today. This is very informative. Also, I'm Teresa. I'm a 1L in the JD program. I guess when I first heard about this case and the tariffs being declared illegal, it kind of reminded me of a Ponzi scheme in the sense that they impose the tariffs are declared illegal, and then now they have to impose new tariffs in order to give back all these refunds. And so I guess I'm wondering, like, for the new tariffs that they're using under the new statutes, such as the Trade Act of 1974, are they going to continue declaring these imposition of tariffs illegal in order to avoid kind of like this cycle of imposing new tariffs, refunding tariffs, et cetera?
Well, it depends on if the court has changed how it approaches this. Because some cases are just perfect. For the, like, this was a narrow victory for the challengers. I don't want to overstate, like, this case is not a slam dunk for the challengers by any stretch of the imagination. And, you know, if the president hadn't gone so crazy with, like, going big, every country, unlimited duration, massive numbers, if he'd slow rolled it out, he might have gotten a very different result. You know, because that is coloring everything. Even though it's a case that's really about an on-off switch, it's the fact that he decided to color so far outside the lines that really got them. It's the same with these other trade statutes. I mean, there were accusations that he was abusing those trade statutes in Trump 1. And cases were filed, and they were, to say unsuccessful would, I mean, you know, we hate to lose as badly as the challengers lost in those cases in Trump 1. But there may be new traction. I mean, judges read the room. Lower court judges try to take not just the explicit cues of the Supreme Court, but like the, you know, like not just the lyrics, but the music or whatever. Like they try to hear what the court is telling them. So we're going to see. I mean, because like the ruling is supposed to send a message.
I saw a hand on the side, yeah.
Hi, thanks so much for doing this. My name is Ben, I'm a 2L at Berkeley Law. So, my question is about if you could maybe go a bit more into other sources of statutory authority for the president to impose tariffs or other revenue-raising measures independently of Congress other than IEPA. I was also specifically wondering about the Defense Production Act. It allows the president to impose regulations to ensure availability of critical goods. So could that potentially be authority for some kind of revenue-raising measure, like to protect American manufacturing from foreign competition? And what has the Supreme Court said about this?
Well, so what, I guess, so I'm not a trade lawyer by trade. I am mostly a Supreme Court lawyer, but I do, because trade is now everybody's business, I do some of this. And there are a lot of disparate authorities that have accumulated over time to deal with different issues. But I'm more interested in the fact that there are actually a lot of basically like super duper presidential emergency statutes that the president so far either doesn't know about or has not touched, that are like out there. Like the U.S. Code is a big code. There's a lot of laws in it, and like you know, the Defense Production Act is a relatively innocuous one compared to some of the things that the president has the power to do if we are in, you know, what the president deems to be dire straits. So, like, again, you know, a lot of this stuff is relatively domesticated statutes. Like, these are ordinary emergencies. When the big gun emergency statutes come out, like, you know, the president can do some really incredible things. So,
What are examples of those statutes?
Yeah, so.
I'm not sure that, I'm trying to think about what I'm allowed to say. So, I'll just,
Maybe we should.
yeah.
Don't give
So
away.
I'll just say,
Yes.
I'll just say, the best example of a high-profile litigation that we've had of this in recent years was the effort by the president to repurpose a bunch of funding from military programs to support the construction of the border wall. And the way it was done was through emergency authority against Congress's expressed wishes, which the president vetoed. And it's hard to emphasize how rare it is for Congress to actually legislate against the presidential declaration of emergency and clearly express its opposition to subsequent actions. And so different circuits address this in different ways, but the Ninth Circuit ultimately found this to be unlawful. And this was about to get to the Supreme Court. The Biden administration came in, terminated the program, and that was that. But there were limits imposed on the administration in doing that as well. I don't know if that is what you had in mind, but that's the best example I have.
That was under 10 U.S.C. 2808, right?
Mhm.
Yeah, isn't that about allowing the military to undertake construction projects when
Yes.
there's an emergency that requires use of the armed forces?
Yes.
Yeah, so are there any more like broad-based ones that you?
There are 150 emergency provisions across the US Code. I invite you to look at the Brennan Center's database and to dig for stuff. If you're planning to propose this to anyone, then that would be a great resource to pursue.
And just if you're interested in particular on tariff authorities, the Edley Center has a white paper that walks through what the existing laws are. So, and they're on our website if you're interested to look at it too.
Related to this discussion, I'm Isaac, I'm a 1L, thanks for this, it's been really great. For both with IEPA and whatever the provision in Curtis Wright was, these both are statutes that intersect foreign affairs and taxing and spending. So I'm wondering if the learning resources case provides any indication of how courts should determine under which category a given statute should be construed as, you know, foreign affairs or as taxing and spending, and therefore kind of determine which branch has authority over it.
So you're asking about Curtis Wright? I heard it. So for those of you who are not familiar, Curtis Wright is a landmark case from the 30s with an opinion written by Justice Sutherland at the time that said that basically the president is the sole organ of the nation in foreign affairs. It was a case about delegation. The delegation was interpreted extremely broadly, and that has been language that has been repeatedly used since then, even as the Supreme Court narrowed its purview in cases like Zivotofsky 2 and others to support broad presidential authority in foreign affairs. To your question, I recommend a paper by Kurt Bradley and Jack Goldsmith about delegations in foreign affairs. And the argument that they advance there is that the key is not the classification of a matter as foreign or domestic. It is rather whether or not a particular power that the president is asserting is an independent presidential power under Article 2. It means that not all foreign affairs are necessarily matters that should be delegated to the president's own or expanded discretion. What you need to figure out is whether or not there is a basis in the Constitution, depending on your preferred method of interpretation of the Constitution, to an argument that says a particular power is an independent or exclusive presidential power. Now in the tariffs case, the court unequivocally said, no, the taxing power is not a presidential power. It's a congressional power, and therefore there was no room for any foreign affairs exceptionalism. And so I think what the court did is essentially accept this theory or this approach that Goldsmith and Bradley advocated for in that article.
And to that point, the Chief Justice goes out of his way multiple times to say, no argument has been made to us that this is a wartime issue, that war powers are at issue. Because the president does have some independent war powers. And so like very suggestive, evocative of like, what could be out there in tariff land and war.
Yeah, I can't help but note, he writes, the Chief Justice writes, as far as I'm aware, or something like that, we're not at war with all nations of the world.
Yeah, that's fine.
That was,
But
A few
to
weeks
this
ago.
line of question and to these two, the last two together, I mean, it's just worth remembering. I mean, in a real war, you have to plan your economy. The United States planned its economy intensely in World War II, literally set prices for all manner of consumer goods. We flipped in from quote-unquote free market to a completely planned economy, won the war, and then flipped back out in the late 40s. So there, I think arguably it's inherent in the idea of police powers that you can do that, whether or not there's a statutory hook. And if we're in a real war, Congress could easily delegate something specific enough to deal with them.
and there's the Trading with the Enemy Act.
There's a ton of stuff like that. So I just mean like in general, like planning is, one shouldn't take this as against planning as such in real emergencies. That no country could be against that. It's about this particular statutory hook and these conditions, I think.
Well, thank you to our speakers. We're at time, and it was wonderful to have you all together, and I really appreciate it.